warm welcome to Bharata First. You're watching Big Picture with me, Frank Rajan Pereira. And to celebrate India's fine performance at the Olympics and Independence Day, we at Bharata First have come up with an exciting offer for the Knowledge Center. Bharata First Knowledge Center is your one-step destination for your competitive exams preparations. Go to kc.bharatafirst.com for more details. Use the coupon code FREEDOM30 for a great discount. Hundreds are thoroughly enjoying this whole new learning experience. Make sure that you don't miss out. Be a part of this amazing journey today. Also, please like the video, subscribe, hit the bell icon, and share the content. You can subscribe to our newsletter for some incisive content. The Bharata First team runs several quizzes. Please participate in them. If you like our content, do keep it alive by making a small contribution. All this information, along with some must-see recommendations, are in the description of the video. Please go through it. And now on to the discussion. The Parliament on Monday passed a bill that seeks to do away with the contentious retrospective tax provision and will impact retro tax cases of Cairn Energy and Vodafone. Before the Taxation Laws Amendment Bill 2021 was moved in the Rajya Sabha for its consideration by Finance Minister Nirmala Sitharanan on Monday, members from Congress, Trinamool Congress and DMK staged a walkout, saying the government had listed the bill in supplementary agenda without giving them adequate notice. The bill proposes to amend the Income Tax Act of 1961 to provide that no tax demand shall be raised in future on the basis of the retrospective amendment for any indirect transfer of Indian assets if the transaction was undertaken before May 28, 2012. In this edition of Big Picture, we will analyze the retrospective taxation amendment. Joining me on the program today are Ajay Dua, former Commerce Secretary, Government of India; Jayant Das Gupta, former Ambassador of India to the WTO; and Shubham Bhattacharjee, editorial consultant of the Business Standard. All right. Thank you so much to all my guests for joining me on this edition of Big Picture. Mr. Dua, let me start the program with you first. What do you make of the retrospective taxation amendment?
Now it has gone, Frank, since this afternoon. I believe back home in India, things moved very fast. Today, even the Rajya Sabha has approved the bill for retrospective taxation being further amended, and the presidential assent has probably also been obtained. So it's the law of the land which says that from the day the last bill was enacted, that's the 2012 one, or the law was enacted, any transaction prior to that date, that means the retrospective aspect of the amendment has been removed, and the Finance Minister has even made a statement in the one of the houses of the Parliament today that this will apply to the two cases on which the international courts have passed judgments against the Taxation Department. 4 cases had gone to the the Appellate's Court of Hague. 2 had gone against the Indian Tax Department and 2 had gone in favor. The ones which were 2 against being the Cairn and Vodafone. So the Finance Minister has made a statement that as long as these companies are willing to withdraw the arbitration, their cases in any tribunal or court of law and not claim any interest, the Government of India is willing to settle the matter with them. In all, 17 cases had been appealed against. As on 17 cases, the retrospective taxation has so far been applied since 2012. So what I'm just trying to say is, what I make of it is that it was a highly desirable step. First of all, it should not have been brought in. And second, if it was brought in, it should not have taken 9 years for government to have taken this, kept it on the statute book. But I believe a responsible statement from a government authorities was, we are testing the law, saying we want to see how it will fare, what we have done, before we take a call. Now that in two large cases, the government could not succeed, and the fact remains that it is retrograde. It is something which was legally not tenable. Supreme Court of India first passed the order saying that it's not tenable. So it is the courts of the international courts have only confirmed what our own Supreme Court said. High Court order of Mumbai High Court was appealed against in the Supreme Court. Supreme Court found it ultra vires. The company, yet we had gone along because we are testing the waters. And I think from today onwards, it might be happy days again, and happy days for the foreign investment, the badly needed foreign investment in India, and Government of India's attempt now to have the sovereign bonds included in the international capital bond indices. Because the provocation is actually that.
Right.
These Indian sovereign bonds were not being listed in the international Wall Street here, London, etc. till such time as this issue had been settled, saying contract enforcement in India is hardly there.
Sure.
So these kind of things were coming in the way, and I'm sure going forward things might be a little better. But first, my other distinguished panelists, please.
Absolutely. So, Das Gupta, Dr. Dua is suggesting that Achhe Din are here, especially as far as FDI is concerned, as well as sovereign bonds in international indices. Your thoughts on this aspect?
Only about 17 companies, I think, were within the ambit of this law as it stood till yesterday. And that has now been repealed. So the tax demand against these 17 companies was about 1,10,000 crores. Now, the government has still reserved its right to tax retrospectively after May 2012. 2012, May was the month in which the retrospective tax law was put in place. And the Supreme Court had earlier said that you can't tax retrospectively. That is what had brought about this amendment. And that has now been repealed. So only these 17 companies will stand to gain. And the government has said that about 8,100 crores will be refunded, of which 7,900 crores will go to Cairn, India. And as far as the others are concerned, there are tax cases which are still pending. So it is not the case that recoveries have already been made and the government would be having to refund a large amount of money. As far as retrospective taxation is concerned, the US, the UK, Netherlands, Germany, and Italy, to name a few countries, have such a law in place. India also has had this law from much earlier. So we are back to square one. We can, after May 12, if any transaction has taken place outside India for assets which are located in India, the government can still collect tax, capital gains tax on those transactions. So I don't think really that, I mean, this was very much needed, and it was something which the industry had also been calling for. But I don't think the scenario for foreign direct investment in India will change very much, because what it will lead to my mind, is that companies will restructure their assets in such a way, which Cairn had done. Cairn UK had tried to divest its shares and give all of its 9.8% shares to Cairn India. And that is what brought about this problem for Cairn India. In the case of Vodafone, it was different because it bought shares from Hutchison Whampoa, and Hutchison Whampoa's shares were in Hutchison SR. And that is what led to this problem. So I think that this will clean up the slate. This will make it clear to investors and to the companies that they have to go about it in a different way. They have to restructure so that this asset transactions abroad are, they take into account the fact that there would be a tax liability from May 2012.
Absolutely. So Shubhamal, let me come across to you now, so let's talk about this other aspect that Mr. Dua raised about, how this law shouldn't have been in place at all in the first place, and why it has taken 9 years to do away. And when it has been done away with, how things have moved so quickly. Your thoughts on all these aspects?
Yeah, interesting. I mean, to think that we have actually spent a decade of our newspaper lives chasing and working on this law. So it's that way, it's quite significant. I would, both Mr. Dua and Mr. Dasgupta have got some very major points that they've made. Let me, first of all, I feel rather pleased that Mr. Dua actually said that it will help in India's inclusion in the global bonds. In fact, today in Business Standard, that's the story that I've written, that India's timetable for being part of the global bonds, basically the global bond indices, like the Barclays or the JP Morgan ones, India should be able to crack it sooner. There's one minor one about withholding tax, which should also come through soon. Once that is there, India can actually be a very easy recipient of foreign money, because those global bonds, indices automatically, but the moment you're part of it, the constituents, as an automatic rule, they push the money into the country. And we can expect around $15 to $20 billion, which is actually a huge amount of money to be able to receive without any much of an effort. And to the extent that the retrospective tax was a thorn in getting it signed, this is really a major achievement. Now to the question about, definitely there is a reason, there's money trail, as they would say, that why it has been removed. Now the big problem with this is that, Dasgupta raised a very important issue, that was it such a big deal. The point is, no one says that tax people cannot go after a taxable event. The problem is that what the retrospective tax did was it introduced an element of mischief. What was this mischief? It said that nobody says, and India also, in fact, if you look at what the Finance Secretary has said, has never said that we cannot, supposing some event has occurred, it is not as if India cannot tax that event. The point is there has to be a deadline by which you have to tax that event. And the deadline today, as per the tax law, is 6 years. Within 6 years, a tax demand has to be raised. If it is raised within 6 years, it is not retrospective. What the Retrospective Act did was it said from the time the Indian Income Tax Act of 1961 came into being, any tax case that has been closed, the government of India has the right to open it. This was frankly a hugely draconian possibility that was created through this act. Mr. Dasgupta is right, there were 17 cases, but 17 is, I think, 17 too many. The very fact that a country can say that I have the right, as long as my income tax acts are there, to be able to tax it from inception is a dangerous tool for the income tax department to be able to use. You've got to have a limitation on your powers. No one says the income tax department should not have powers. But how far can you go back? So today, for instance, when we say that does the government have the right to tax an event, like say a merger event, like same as Hutchison Whampoa, yes, even if it has happened earlier, government can tax it. But for how long? The point is that we have to be able to tax it within 6 years. The courts say that is fine. If the tax demand is served within 6 years, it's a fair enough taxation charge. But if you have not done it within that, due to your inefficiency, you cannot say that, oh my God, I forgot. And I'm going to wake up today and raise my tax. No investor will be able to do business comfortably if that sort of a Damocles sword hangs on, which is what is the significance of this. So again, to come back to the point, was a tremendous amount of money came in through this taxation? No. But a tremendous amount of bad will came in through this taxation measure. We were seen as a country that can, among many other things, can create a tax. The word was terrorism. That has been given a decent burial by the amendment that has been passed by the Lok Sabha and the Rajya Sabha.
Right.
This is the significance of this, I mean, the bill which was steered by Finance Minister Nirmala Sitharanan this week in Parliament, and which is why it is such a big deal.
Absolutely. Yes. Absolutely. Yes. Mr. Dua, so what does this mean for these, the companies that have been bearing the brunt of this, namely Cairn and Vodafone and many others?
Frank, Vodafone hasn't paid up, but it had become liable for a payment of not just the 11,000 crores which it had been sought from it, but a fairly large amount of interest rate, and at last reckoning, the total was 23,000 crores. This is happening at a time when already the government has opened up for itself, saying we can also revise the spectrum rates, recoveries from all the telecom companies, that other bit. Now, in addition to that, if they had to pay up this 23,000 crores, or whatever the precise figure would be, I think it would have seen the demise of Vodafone Idea as a combination in India for sure. It would, the figures Jayan mentioned, about 7,000 odd crores was expected from Cairn, which is demanded back, and the courts have put the Indian assets in Paris on the leash, saying these can be, for whatever they are worth, they allowed them to kind of realize their dues. I am not so much on the company issue as saying what we have achieved today, and Jayant would agree that it is bringing in a degree of tax certainty in the country, which is extremely important from the FDI's point of view. It is also, what Parthasarthi Shom, who was asked to once look at when he was an economic advisor, chief economic advisor, to look at the taxation, the retrospective taxations, his committee had talked about predictability, certainty and stability in the Indian taxation system, and that in no way is taking away the saying that the sovereign does not have a right to tax. But if you or sovereign cannot even go about cannot even do retrospective taxation, because first of it is, Frank, I think it's a judgment of the Supreme Court of Chote Lal versus the Union of India in a tobacco case. The government of India had at that point of time levied a tax on tobacco, higher taxation on tobacco, from the day it introduced the bill in Parliament and not from the day it received the presidential assent. So there it was just a very limited issue, saying yes, the day the bill was passed, it is retrospective, but that retrospection was only with respect to it was clarificatory in nature, and it was to make sure that the intent of the Parliament is carried through by the last. When it was enacted, it wasn't conveyed clearly. Subsequently, it has been done, and the difference was only those few months between introduction and enactment. So the court upheld, saying Supreme Court at that point of time, I'm talking about early 60s, that the government of India does have powers, but it cannot do it retrospectively from the day it introduced. It becomes effective from the day it got it passed. So, and that's when it came on the statute book. You can try your luck, any government can try getting things passed in Parliament. but till such time as it's done. So I think this is giving a degree of stability, not taking away the government of India's powers to introduce retrospective taxation to the same extent as correction of laws. Retrospectively, if one law has been passed, the courts have said if you need to pass another law to correct, meaning just not enact an altogether new law, but to make sure that your intent, if it was not expressed properly, can be done through amendment, and that includes retrospective taxation.
Sure.
But having said that the sovereign powers are there, what is necessary is that if you are in a competitive world, the access, India might be attractive today, yesterday it was China, for years together it was China, tomorrow it could be somebody else. We have to play by the rules of the game, and one of it is tax certainty, predictability, and fairness. Fairness is something which even the Supreme Court of India emphasized. Seeing that a person, you have closed your book, and that's the point which Subha was referring to. 6 years is a good enough time. The law had provided for 6 years that if any mistake had been made by a tax department person or anybody, you could reopen a case, get it, but it doesn't mean forever. You can be going back and saying, I can open it from that 1962, because after in 61 the act was passed, 62 the income tax rules were made, and from that day onward I can open up anything, which is what late Pranab Mukherjee as a finance minister, competent and highly able that he was, I would think that he made a mistake of, that particular bill first said that this is clarificatory in nature.
Sure.
Then thereafter, after saying clarificatory in nature, then they attacked us on a substantial point. So it was a mix-up thing, if I can say that. Why it was done, we don't know, but it was there and it has done us a damage. And second, we are competing in the world with bilateral investment protection agreements. We have one with the UK. This was covered under the Netherlands one. Because we have one with the Netherlands, because Vodafone is registered there. And we are banding this around when we negotiate the CPAs or the comprehensive agreements, saying we are willing to do this. I remember when I was involved with this exercise as the Secretary Industries, along with my colleagues in the Commerce and elsewhere, that we said BIPA is available. Now let's talk about other things. And this was being referred to as BIPA.
Right.
And finally, we are also signatories to UNICETRAL. The UN law also on this subject is there, and we swear by the UN laws, etc. And here we were going against that as well. So
Sure.
This is a correction and showing that we are we honor our international obligations, and even if it means delay, thank God it is there, and I'm happy about it. I reiterate.
Okay. All right. So let me take the points that you're making forward then. Mr. Dasgupta, would you agree that there is some kind of certainty, stability, and fairness now in the Indian taxation system?
Yes, I agree entirely. That first thing was that this piece of law, the amendment, was a bad law to start with. Just to give an example of the relationship with criminal law, more than 300 years ago, it was outlawed in England that you can't have a retrospective law brought in to make an act criminal. That was well established, because in a similar vein, if you had done something in 1963 or 62 and you were liable to tax plus interest, just imagine what kind of havoc it would have wreaked on a company. So this was a piece of bad legislation. It had not been in its exact form. It had not been there in any foreign country of note, the Western world. So this was the first thing which has been done to set the balance right. The second point is that it still reiterates the sovereign's right to tax. And as Subhamay has mentioned very pertinently, within 6 years, you have to issue the notice. The Vodafone deal took place in 2007, and the notice was issued soon afterwards. The Vodafone deal took place in 2011, and again, it was within 6 years. So all these things were taken care of, but retrospective effect of some action which was not taxable earlier, and that is what has been addressed. Now, it does lend a lot of certainty and assurance, gives a lot of assurance to investors. I agree there entirely with Dr. Dua. The point is that there are a large number of items still in our Income Tax Act which are open to interpretation. You know, in the case of the US, the Income Tax Act is a very slim volume, and the entire thing is based on case laws which have been decided. That is a very thick tome of course, in India also a lot of judgments are available. So the endeavor of the present government is to make the income tax law very simple and effective at the same time, and do away with the exceptions. So this is, I think, a step in the right direction. It is a very welcome step, but there is a lot of ground still to cover. And to make our Income Tax Act transparent, fair, and give a great degree of predictability about it, because foreign investors, when they invest in India, will like to know what would be their liability to a great degree of accuracy. You know, they can't say that it will depend on the income tax authorities and then the appellate tribunal and then the High Court and the Supreme Court. So this is work in progress. The first step has been taken in a major way, but a lot of work needs to be done still to provide that degree of predictability. The last point I wanted to mention is that the government is now trying to bring in a system which will make, for instance, for personal income tax, it has already introduced the system that assessments will be done not by a designated officer. It would be done on a computerized platform, and a lot of artificial intelligence would be used for that. So this person-to-person interaction or the personal angle involved about judgment, etc., will be eliminated. I'm sure this will soon be adopted for the corporate tax arena as well, which is slightly more complicated. But softwares are being developed, artificial intelligence has taken great strides. So this is something which will go a long way to provide that kind of certainty, and also to take home the message that the Indian government is not living in a cocoon. It is alive to messages which are coming from investors, that it abides by the rule of law, because the Permanent Court of Arbitration at The Hague in September 2020 had ruled in favor of Vodafone. In December 2020, it ruled in favor of Cairn India.
Right.
So we abide by an international arbitral award. That is also a very, very important message which it upholds.
Absolutely. Absolutely. All right. Interesting points that are raised by Mr. Dasgupta. Let me take them forward with you, Shubham, and talk about this aspect of, this is just the beginning, and there's so much more to do really as far as taxation is concerned, and it's a work in progress. Since we are here, what needs to be done next?
That's an interesting point. In fact, I've often wondered, even on this retrospective tax, today everyone is cutting their losses and blaming only one person, which was the then Finance Minister Pranab Mukherjee. But was he the only one responsible? I refuse to accept so. The Indian political government, the government in power has to take the responsibility.
Of course.
Just as the government in power today has to take the responsibility that it actually waited for 7 years. to be able to drive it through Parliament. And as Mr. Dasgupta rightly pointed out, it was probably precipitated by the Judge Arbitration Awards in Vodafone and the Cairn case. But what sort of accountability of the political executive or of the permanent executive in India is there that they could actually come up with this tax? I mean, today, like everybody whom I have talked with have said today, I mean, in the sense, not literally, but like over the years, people have said, no, it's a wrong tax. But then why was it allowed? Was he the only, I mean, was that finance minister so powerful that everybody was silent? Because unless we answer these questions properly, we will not be able to say what needs to be done. To the question what you're saying, then what are the further reforms to be done? Because then who takes the responsibility for those reforms? Will it be the junior most tax officer? Will it be the joint secretary in the tax departments? Will it be the CBDT as the CBEC chairman? Or will it be the revenue secretary or the finance minister or the prime minister? Who actually is responsible? We have to be clear, make that after this tax is done, I think a very important thing that needs to be done is to fix accountability. And this will create a lot of, I mean, it'll create, I mean, it doesn't mean that somebody goes in front of the court, but there has to be an understanding of how this sort of a sordid business came about. Unless we are able to fix that problem, unless we are able to understand this, we shall not be able to go around with the next step. Because the investors will also say the same thing, that today you can write a pretty piece of purple prose in the tax laws, and tomorrow somebody else can change it. We are talking about the need for certainty in our tax laws. We are talking about the need for responsibility. Mr. Dua also pointed out rightly. But who will believe, and I mean, both of them are absolutely right, who will really believe it unless we know that who has to be blamed for the past? And I refuse to believe that it's only one finance minister.
Right.
Unless these issues are handled properly, I think the scope for mischief will remain in one of the other statutes in our FAT, income tax and indirect tax laws book, which can always come up to create problems for us. Yeah, Frank.
I know Mr. Dua has a reaction ready for what you have just said and is just waiting to go, but it's time to get quick closing comments from all the panelists, starting first with you, Mr. Dua.
I'm one with both Jayant and what Sumoy said right now. All that I want to say is that the responsibility, to Sumoy's question, is it's the parliament of the country. The finance minister by himself cannot, he can have an idea, his colleagues in the cabinet agreed with him, prime minister endorsed it, the parliament, the two houses of parliament passed it. So ultimately, the idea may have been Mr. Pranab Mukherjee's. But as a finance minister, he had to make his the budget balance, so-called balancing the exercise. Where do you ask me to spend? Where do you get the money, etc. from? But it was a government of the day which was responsible, and I would say it was the parliament of the day which went along with the government. So it has to take the responsibility. So it's not just Mr. Pranab Mukherjee, for whom I had great regard as an administrator and a person who was running the government, almost running the government on the finance and the economic affairs side when he was the finance minister the last time. 50-odd groups of ministers he was asked to chair, and for each one of those, he came up with solutions which otherwise seemed intractable in the larger cabinet. Having said that, I would want to see, Frank, merely one thing more, that we have an arrangement like many other countries about advanced settlements. Foreign companies wish to know their tax liability by going through the process from the income tax authorities, saying what is our liabilities, because they want to show that as their cost while they are working out their budgetary maths of operational investment and others. We have to, once we have given us estimate, and the 10 years ago or 8 or 9 years ago, something called the APAs also we started entering into between foreign companies and Indian tax company. A Japanese company called Mitsui was the very first one which signed it. And what was it? Saying transfer prices agreement also we are making now. Because all companies, particularly which have branches, subsidiaries in India, parental companies outside. So the taxman would go into that and say, you are showing much more expenditure than it is really admissible. So the government of India in the revenue department, when our present governor Shashikanta was the revenue secretary, it started at that time. These agreements started getting signed. And so if we do, and based on that, the guys started going to the settlement department, commission side or settlement department, paying the requisite fee, etc., and getting the estimates. So this particular capital gains liability and the withholding tax amendment retrospective brought about even uncertainty in minds of foreigners saying, we've got these estimates, but we don't think if the government of India can change the basic law. All this thing goes for S6.
Sure.
So those kind of things, granular now, things need to be worked upon, saying, yes, because of this law, we will, whether we'll change these APAs, whether we will also be changing our settlement awards, which are given to the parties on the basis of which they have taken decisions, those things will also need to be gone into.
Absolutely. Mr. Dasgupta.
I would just like to make one point, and that is that income tax does lead to a great deal of litigation, mainly by the government, but also by the SSE. And one of the things which will help our business no end will be to have a fast-track mechanism for disposal of matters. Apart from the very important point that Dr. Dua has mentioned about the advanced rulings authority. In the case of customs also, we have an advanced rulings authority. But unfortunately, there are several flaws in partly our legislation and partly the body itself, which do not allow for very quick disposal of cases and a firm footing for the rulings which have been given. For instance, still quite recently in the customs case, the ruling was valid for one commissionerate. It was not valid for another commissionerate for the same product. So all kinds of problems were there. I am not very familiar with the income tax advanced rulings authority, but that needs to be made a very robust authority so that people can take guidance from it, and it will be in most cases adhered to by the department and the courts as well, because the advanced rulings authority is normally presided over by a retired Supreme Court judge. That is one thing. In the matter of enforcement of contracts, for instance, we have now set up a separate mechanism, of course, comprising the same district judges and the High Court, but a separate mechanism so that we can dispose of these matters quickly. Income tax liabilities also, because they will have to come on the balance sheet, that this is something which has been demanded by the tax authorities and it has still not been paid. So it is a liability pending litigation. Now that does affect the functioning of a company, because provisioning has to be made.
Sure.
So now this is the kind of thing which needs to be sorted out, because if we want to join the ranks of the developed countries and make it a very investor friendly and give that kind of an environment to companies and foreign investors, we also have to dispose of cases very quickly. So that is the second point which I would like to stress. Already in the High Courts, there are designated judges, but what we need to do is to have a clear understanding that income tax cases will not be kept pending, for ages in the lower court.
Sure.
Income tax commissioner's court, for instance, then the tribunal, then finally the High Court and Supreme Court.
Absolutely. Absolutely. All right. So Shubhamay, please close the show for us with your concluding remarks.
Yeah, I would say, exactly. We all seem to be agreed that that's the way it can be that is how it should be done. Essentially, the rot happened at some time. that we have been able to clarify is probably a great thing on the 30th year of liberalization, that we have done something very major. In fact, this year there have been 3 major steps on tax issues. One is that India has become a party to a multilateral tax regime, which India has been refusing for so long because we are not very comfortable discussing our sovereign rights. 2, that we have agreed on retrospective tax, that even though if you have sovereign rights, we should not use it. And 3rd, that we have started negotiations on a very major trade deal, which is with EU, with the UK, where again we are going to have to curtail some of our sovereign rights. So probably these does show a maturity of the entire tax and of the entire polity, and hope that that is what we shall be looking forward to when we come out on the other side of 2022, just not of COVID.
Right, absolutely. All right, gentlemen, we'll have to leave to that. Thank you so much for joining me on the program and putting things into perspective for us. Coming out of this discussion is that retrospective tax amendment is a good move. The law should not have been enacted in the first place in 2012. It was a big mistake, and it should not have taken 9 years to get rid of that mistake as well. However, now that it has been done away with, it is a very positive development. What we need is fairness, certainty, and stability in the Indian taxation system. In a competitive world, we have to play by the accepted rules and honor international obligations. Doing away with the contentious retrospective tax provision is one step towards a better tax system and regime, and a work in progress. That is, however, a long way to go. And before I go, let me once again inform you about Bharata First Knowledge Center. To celebrate India's fine performance at the Olympics and Independence Day, we at Bharata First have come up with an exciting offer for the Knowledge Center. The Bharata First Knowledge Center is your one-stop destination for all your competitive exams preparation. Go to kc.bharatafirst.com for more details. Use the coupon code FREEDOM30 for a great discount. Hundreds are thoroughly enjoying this whole new learning experience. Make sure that you don't miss out. Be a part of this amazing journey today. Also, please like the video, subscribe, hit the bell icon, and share the content so that more people get to know about Bharata First. You can also subscribe to our newsletter to get some incisive information. The Bharata First team runs several quizzes. Please participate in them. If you like what we have in store for you here at Bharata First, do keep it alive by making a small contribution. All this information, along with some must-see recommendations, are in the description of the video. Please go through it. That's it from me. See you again next time.